Monday, April 22nd, 2024. Madam Clerk, would you call the roll?
Mr. Ron Whittington. Mr. Thad Mosley. Ms. Christy Elflin. Here. Mr. Gary Paytow.
Here.
Mr. David McGraw.
Here.
Ms. Frances Pawlowski. Here. Ms. Megan Edwards. Here.
Okay, courtesy of the floor to visitors, we have one David Smith.
Well, I'm speaking on the agenda item.
Do we want to wait for that?
Yes, we can come out
Okay.
to that. Yep.
Approval of minutes.
Do not have any at this time.
All right. Any old business?
I can just kind of give you guys just a really quick update. I know we normally have a written staff report. We will have a pretty hefty staff report at our May workshop. Gary, good call on the pavers along 3rd Street that were damaged around those stormwater drains. We did get some engineers out here to take a look at those to ensure that it was just an aesthetic damage, not something structurally damaged. They were able to confirm that. And Public Works had some crews out there, some pavers, this end of last week and this week repairing those, so those will be done this week. And Parks is also working on finishing up the landscape around the Ritz parking lot for us to then get down there and take a look and kind of decide how we like that. We also had a really good landscaping meeting regarding the landscaping surrounding the sculpture that will be where the former War Veteran Memorial is going. So those meetings have all been really good. Like I said, we will have a much more in-depth report at our workshop.
Any questions for Taylor? All right, new business. I want to acknowledge Taylor gave me an email, and so I guess what, you're going to send that to everyone after this meeting?
Yep.
For everyone to read. And then I guess it's now the time.
Yes.
Okay,
Yes.
guys, to come up and speak. Mr. Smith,
Does the applicant go first?
does it?
Generally, Mr. Chair, we'll have a report from staff and then the applicant and then public comment.
Okay.
All right.
Good afternoon, Christian Bavoli, Senior Planner. I'm just going to kind of briefly go over the application and what the proposed rezoning is for. As you know, the property is located at 602 First Street North, which is the existing Mangoes, and then there are 3 other parcels immediately to the west that are part of this request. Currently, the properties to the west are zoned Central Business District, and then the existing Mangoes has a redevelopment district zoning that they sought, I think, in 2004, or 14, excuse me. In essence, the surfer bar was supposed to go there, and it ended up going in its current location. But that particular RD zoning tied them into a very specific site plan, and Mangoes has been interested in doing some renovation, rehabilitation, and adding on a little bit to their existing building, but that limited site plan didn't give them the option to do that. So that's driving part of this request, to basically free them up to redo Mangoes to an extent. They're not going to tear the building down, but spruce it up. They want to add an additional restroom, expand the patio a little bit. In addition to that, the properties to the west are currently older multifamily structures. The applicant is requesting to take those down and then put in a mixed-use project, which would include ground floor retail or office space, and then upstairs an opportunity for restaurants with outside seating. The ground floor will be smaller than the upstairs, basically, to allow for better traffic circulation. The applicant is providing all the necessary parking, so they're not paying in lieu for any parking. They also intend to do a valet service, so part of the design of the project allows the drop-off and pickup underneath the covered portion of the building. The biggest difference between this and the traditional zoning, aside from some of the mixes of uses, is the list of uses allowed in the Central Business District would become fully permitted, so they wouldn't have to come back before the Planning Commission to ask permission to do some of the things that technically they can do, but typically there are opportunities to put conditions on those. So the Planning Commission and Council would have an opportunity, if they felt there needed to be conditions, to put them into the PUD, or RD, excuse me, and then those could apply universally to the whole project. So it basically frees them up to do what they need to respond to market conditions without having to go back through additional steps. Staff has reviewed the application. We feel that it meets the requirements of the Land Development Code as well as the policies laid out in the comprehensive plan. Also, the Specific items noted under the redevelopment plan on the last page right before the staff recommendation. And we are recommending approval based on that information. Happy to take any questions. We do have the applicant here as well.
Any questions? Francis?
I have a lot. I had to dig back, all the way back to 2016 to go through all of these things we talked about in this development plan. I re-reviewed the 1987 and the 2030 comprehensive plan and our professional analysis of those changes from those plans, what we paid for in 2020. And there was a couple things on here that I wanted to ask. On the houses that are being demolished, are they obviously not considered historic?
No, we currently don't have any formal recognition of historic properties in our code.
Okay.
We're hoping to add that with the new comprehensive plan.
There was a section in here, I think it was page 4, that talked about, like you were just mentioning, about, this is outdoor landscaping. The larger patio that they're talking about, is that going to extend past the current property line of Mangoes to the west?
No, Mangoes is pretty much going to stay in the same location. There's quite a bit of a gap between Mangoes and the new structure. So they're going to stay within their existing footprint. They own the southern parcel and the one to the north. Those 3 other parcels are being added on. Mangoes is going to stay in that initial 2 parcels that they own currently.
And the reason they're doing this combined planning is so they can get around the expired provision that they were given after it was rezoned. Is that what I understand?
So there's a bit of a issue with that. Our code currently has an expiration on redevelopment zoning districts, but per state law and a lot of case law, zonings can't expire. You're basically extending a series of land use uses to that property, and if you were to take them away, it could be considered something that would turn out to be a taking, and therefore they could seek financial compensation for that. So although our code does say that, it really isn't something that we can actually put into practice. So that initial RD rezoning stands.
Okay, so then that brings me to the question of if they're 2 separate buildings, but they're being bundled together for one request to bypass the west side's requirements, which is different than what the east side requirements are. Is there any way that they could unbundle these 2 properties and only update one of them and not do the rest?
I mean, that would be up to the applicant. They're asking to do all of them. Nothing in what they're proposing changes any requirements that they would have to meet as far as the typical design of the building. They're still going to meet all of the landscaping and parking requirements. The central business district generally gives a lot of flexibility to that anyway. But the actual nuts and bolts of the construction would be handled through the development plan review and then finally the building permit. So generally it's the overall design and the uses that we're looking at today, but they would meet whatever requirements either are in the code currently or you guys feel they need to.
So the reason I'm asking that question is it seems like there's been a lot of builders and developers in this area that will start something, kind of get something approved, and then they kind of abandon it. So I'm trying to get to the point of, there is no way that this gets approved, that they can just expand out Mango's patio and just ignore the west side of the project.
I mean, in theory, we've done projects like the gallery project, where we put them on basically a phased schedule, and they are required to do certain things to achieve further expansion, like provide parking or additional landscaping as they grow. But obviously, the actual construction and the timing of that's mostly driven by their economics and the market.
So the answer is yes, they could.
Correct.
Let's see, I'm only on page 6, give me a minute.
No, you're fine.
From what I read on here, there's lots of use in verbiage and it's lawyer speak, so I am not going to even try to go into it. But they keep referencing the redevelopment plan in 1987, and they keep saying that it meets the standards of that and the comprehensive plan. If you go back into this plan and you look back at all the different times we've gone through it, including when we did proposals, individual proposals 4 years ago, and what to do with all these things, that zone is actually, that area west of 5th Street is actually, and this is just so you guys know, it's designed to be the residential area, not the car and mixed use residential area from everything I read. So if I'm incorrect, I don't mind being spoken, but if you look
So if you look at that Shepherd consolidated plan, that's one of those things that's obsolete. So the zoning allows for residential, but it also allows for all these other commercial things. So
You're saying,
the intent of those diagrams that you have there in front of you that was what the city wanted at the time in 1987. The landscape has changed. So it's not necessarily that we can't allow a property owner to move forward with something that's not residential just because in 1987, the CRA at that time wanted it to be residential. So those are parts of the plan that are considered obsolete and no longer relevant.
but
A lot of the other stuff is.
But when we went through and did the 2020 thing, we still had deep discussions about corridors and what have you, and that being the area. So I know the Johnson Johnson building technically shouldn't have been built there because it was inside that zone that shouldn't have been for what it was either. So are we basically saying that, I thought we were under the understanding that we were reworking the documents or we putting some verbiage in there, so we're just gonna basically wing what we want until it's like, what are we basing this on?
We're basing our decisions and our recommendations on that consolidated plan that tells us what's still relevant and what's still inactive, because some parts are considered obsolete based on all the updates that were made over the years. I think there's 8 different amendments. So we haven't had that discussion yet of exactly what we want to add into the plan for what we're going to do down the road and actually putting it down on paper. We've had those discussions kind of in theory, but not the entire 1987 plan is still in effect.
So you're talking about the 2007 vision plan?
The 2007 vision plan and the 2015 action plan, yes.
So then, if I may still, so that means that when it goes to page 7, and I guess it's even page 6 where it says that the description of property development is to include dwelling and residential, it says absolutely 0, and the same with the proposed project includes so much space in residential, it says absolutely 0. That is still based off you guys' recommendation that we have residential on the property.
They are not, the applicant is not proposing residential on this site, correct?
Mr. Chair, I'd like to add something.
Yeah.
Thank you. We get a lot of talk on these corridors, and that is something that we're looking very hard at when we're updating this plan. However, in the Shepherd consolidated plan, and I have them up in front of my face right now, the 4 corridors now are Gateway, Civic, Pier, and Retail. So there is no, when we consolidated in 2020, there is no retail, no residential corridor at all anymore.
Okay.
And the goals were to create economic vitality in the heart of the central business district, which this property falls within the central business district. So that's kind of the basis why staff is making that recommendation.
Okay, almost done. Additionally, I saw that there was engagement on Fifth Street, not Second, which just fits with what we were talking about for corridors as well, but it did say that it was good, obviously with restaurants, since it's gonna fall under restaurants, does that mean we're extending out our liquor expansion in the beach area by restaurants being allowed to have liquor license as well?
If they qualify for a 4 COP in the
If
state.
they bypass that, like 500 foot or whatever.
Yeah, as you may recall, we did a special bit of legislation through the state that allowed for a reduction in the size and number of seats for restaurants. So it allows these smaller restaurants to get a full liquor license, provided that they meet the requirements of a restaurant, 51% sales for food and things like that.
Yeah, based on their application, they would fall under the original statute of 2,500 square feet and 150 persons, even though we locally lowered it for the central business district. What they're proposing for the restaurant far exceeds that.
Those are my direct questions, thank you.
Any other questions? All right.
Thank you.
I have a question about I know we're not redoing mangoes, they're just gonna add on to it, but if it was redone, they would be required to build up to First Street, yes?
Yes, if they were to tear the building down and start from scratch, they would have to meet all the requirements of the central business district. But as they are now, since they're not going to be demolishing it, they are changing the entrance on First Street, so it's just a one-way in, which does alleviate some of that potential pedestrian conflict with cars coming out onto the street. But we couldn't necessarily have them remove their entire driveway because they have it now, so that was a bit of a compromise. But otherwise, yeah, unless they tear it down, they're not required to meet all those requirements.
Well, I mean, this might be a question for the applicant rather than you, but the point of them not tearing it down, is it because they have too many parking requirements? Like if they had less parking requirements, then maybe they could expand that out to First Street?
No, I think it's a function of the existing establishment has a very strong following of locals, and they don't want to impinge on that. But yeah, they would be better to answer that question.
Okay.
Any other questions? All right. What's my next step here?
The applicant would like to come up and say.
Would the applicant like to come up? Say your name and address?
Yep.
Right?
Yes.
Hi, good afternoon. I'm Wyman Devan. I'm with the law firm of Rogers Towers. We represent the applicant. Our address is, well, my office is in downtown, 1301 River Place Boulevard, Suite 1500. I just want to let you know we have the owner applicant, Mr. Stake, here. We have a representative of the engineering team here as well. Again, just to put a fine point on it, with Mangoes, they're just adding a men's room on the north side and then an outdoor patio on the south and that wraps south and east. And that will, from the site plan, come up to the property line. And you have your expert staff report that says we meet all of the applicable conditions. So with that, I'll just say available for questions.
Any questions from the board to the applicant? Steve?
What, in addition to the restroom and the porch, are there going to be some updates? It made it sound like in the description there would also be a renovation of the building, like to try to clean it up a little bit.
Well, I'll give a first pass answer and then I'll let Mr. Stake respond. But there's definitely been some interior renovations over the recent past. But as to the exterior, I'll let him upon if he wants to share any information.
Good afternoon, my name is Greg Saig, I'm the property owner for the applicant, and to answer your question directly, we took it upon ourselves to put a women's restroom, a new women's restroom inside. We're unable to fit another men's restroom, so we're trying to just expand on the north side to put a new men's restroom in there, and then just to do the patio. We've recently just painted the whole building and cleaned it. When we did the women's renovations, we cleaned it up and painted the whole building. We did other TLC aspects to it when we put the women's restroom in. And, outside of that, I know we want to get it up to code with the new landscaping plan that's on the civil plan and such like that. And so that's what we'll do.
Thanks.
Okay.
Any more? Any other questions? Okay. Now do we hear from, okay, Mr. Smith, would you like to come up?
Thank you.
State your name and address for the record.
I'm sorry?
Can you please state your name and address for the record?
Yes, I will. So we object to the project. My name's David Smith, 135th Avenue North, Unit 201, Jacksonville Beach, Florida, 32250. We are adjoining property owners and residents on the adjoining property, and we are an affected party. Our property received an approved development order as Osprey Court residential mixed-use development according to the Residential Villages land use of the 1987 redevelopment plan. The public notice we received as the adjoining property owners and the planning department staff report, what we just heard, states that parcel 2 Mango's Bar is already zoned redevelopment district. However, the application states that is not currently zoned redevelopment district, but commercial business district. The applicant states that the reason they are submitting the application is that the prior redevelopment district has expired. So the question remains, what is the current zoning of the property? Is the planning department correct, or is the applicant correct? One reason that this question remains unanswered is it appears that the process specified for redevelopment district zoning specified in LDC 34347 is not being followed. First, a representative of the redevelopment agency was supposed to attend the pre-application conference for the rezoning. I've not been able to find out if this occurred. Next, on the day the application is determined sufficient, the planning and development director, quote, shall forward the application to the Jacksonville Beach Redevelopment Agency for its review and recommendation. The application was determined sufficient April 4, 2024. I don't believe it was forwarded that same day to the Jacksonville Beach Redevelopment Agency for its review and recommendation as required by 34347. Excuse me. After receipt, after receipt, the CRA has up to 25 days to review the application and prepare a report based on the standards in section 34-347C3. After completion of the CRA report, the Planning and Development Director, quote, shall mail a copy of the redevelopment agency report to the applicant on the day the report is completed, along with written notification of the time and place the application will be considered by the Planning Commission at public hearing.
Mr. Smith, can I jump
In this case, Planning Commission hearing, I'm sorry?
Can I jump in and ask Taylor something real quick about another point? Did we have anyone of the board attend the pre?
So board members do not attend those, staff does, and the CRA staff was present at that meeting.
Okay.
I didn't hear her answer.
What's that?
I did not hear her answer.
Yes.
Can you
I'm sorry, I'm pointing hard at
That's
you.
okay.
I said yes, staff was present at their pre-app meeting.
Okay, thank you. Continue.
I would ask whether staff is a representative, but we'll go on. In this case, the Planning Commission hearing was scheduled simultaneously with determination of sufficiency instead of after the CRA report was prepared. Obviously, the intent of 34-37473D is to involve the CRA in the redevelopment district rezoning. It provides the CRA an opportunity to participate in the pre-application meeting and provides for the CRA to receive a copy of the application expeditiously the day it is determined to be sufficient. Most importantly, it gives the CRA an opportunity up to 25 days to carefully review the application and determine whether it meets the 10 criteria listed in the Planning Department staff report attached to your agenda. Excuse me. The LDC requires a report from the CRA, not a vote on the requested action for this agenda item. The report is to come from the CRA, not rubber stamping the staff report prepared by the Planning Department that is included in the agenda package. The staff report fails to address key aspects of the rezoning related to the vision plan portion of the redevelopment plan, allowing an exemption from our alcohol ordinances related to bar density and an exemption from the conditional use permit requirements for bars and outdoor bars. These were designed to protect residential uses such as ours in an area designated residential, commercial, mixed use. I'm going to pause for a moment. The plan still says residential, commercial, mixed use. The map included in the vision plan shows it as such. And an attorney can't modify a redevelopment plan according to Florida statute. It's up to you to do it and then the city council. So that simulated plan, they call it, for Mr. Shepherd is not an official modification. Sorry. I'm sorry if I repeat myself. The obvious intent is that the Planning Commission need to be scheduled after the CRA issues the report to provide the Planning Commission the studied opinion of the CRA as to the redevelopment plan compliance prior to consideration of rezoning. In this case, the Planning Commission hearing was scheduled before the application was even forwarded to the CRA, and it's scheduled for today. To ensure the essential elements of law, requirements of law have been observed, I request the CRA table this agenda item and prepare the requisite report within 25 days of receipt of the application by the agency. That will allow time to determine the actual current zoning of parcel 2 of the property and allow correction of either the staff report or the rezoning application as necessary. I would also request the CRA hold a public hearing on the report prior to its finalization. Upon issuance of the CRA report, then the Planning commission hearing can be scheduled as prescribed in 34-3473D. Thanks so much.
Thank you. Do you have any questions for Mr. Smith? Oh, all right. Items for discussion. Francis?
Is this not the time that we discuss our thoughts before we go?
Yes.
All right.
Yes.
I would like to speak on that aspect if possible. I do take a step back to being told that the Gateway Menu of Ideas and Vision Plan and the Shepherd Plan that we paid to have done to review our 1987 plan and our vision plan and the comprehensive plan, I do take stance that I don't appreciate that we're saying that that's not consequential and we're kind of just winging it. I know that may not be exactly the words that you said, but I do feel like we as a board have been directed and have paid for professional advice and guidance on what we can and cannot do. Is not necessarily our job to say what we like in the downtown area. It's not necessarily what, our opinions. We're supposed to be following what we're told to stay inside some kind of guardrails. For those of you who have not been on the board, there have been many variations of this, but as a board member, I feel like a senior board member, I have been reviewing all of these documents, and to my best understanding of this, I do not feel like this fits inside those parameters that we have been working through to kind of figure out, even though we have been pushing for multi-use. I don't think a restaurant on the second floor with a restaurant storage and maybe a small space of retail in the bottom fits that parameter personally. That is just for discussion purposes, even though I think the concept is great. I think it would drive economic business, which is also one of our purviews as a board. We're supposed to bring newer driving forces of tax revenue money back into the district. I think it would 100% do that. My question and my worry is us as a board is going outside of some purview that we are allowed to do. And I'm having a hard time, just based off the documents that we have been charged with, to try to fit any kind of development in this area. And that's the only part of the discussion I'd like to just bring up.
Anyone else? Okay, this is where I entertain a motion.
Yes.
Just call it that. I will entertain a motion. Chrissy?
Can I ask a question before we move there?
Yeah.
Everything that this gentleman just brought up about our timing and stuff, can you speak to the legality that we are doing what we're supposed to be doing in the right pace?
In regards to what your approval or denial today would dictate, is that kind of what you're asking?
Yeah,
Okay.
we are,
So,
I understand we are following the right.
yes. So we're in a unique situation because we have a separate CRA agency of the council. That's not the case in every state or every county, city in Florida. So CRA and PC both review this. You guys have the liberty to table things. You can say, we absolutely say no, or you can approve it. Because you're not the governing body, you're not the city council, whatever decision you guys make would still be reported to council. And then at the end of the day, if council gets a, recommend rejection of this, then it is up to council to either take that recommendation or not. But this is, and we have our attorney in the room present. Previously, we did one of these back when we did the gallery project, and we followed the guidance of our city attorney then. And so, yes, this is what we've been instructed to do.
Okay, thanks.
Mm-hmm.
So one other thing, I think the design is great. Anything Crop Juke does is always high quality. I do wish that Mango's could somehow approach closer to First Street and get a little bit more pedestrian, but that's obviously not gonna happen with the existing footprint. So, but I think it'll be a good addition to our central business district.
Gary?
Mr. Chairman, I think it would be appropriate for City Council to address some of the comments by the individual, Mr. Smith. There's a number of legal aspects that were presented, and I'm not sure I understand exactly where we are in relationship to those. Have we followed all of the steps? Do we need to backtrack and do this report that was identified in his comments? Obviously, he referenced certain legal documents, but off the top of my head, I'm not sure that make sense for us to postpone it for 25 days and get the answers to the questions before we move forward with a, determining factor here. How do we fit into the overall plan? Personally, I'm going to be very blunt. Personally, I have a problem that we don't have a plan for the downtown district. We keep saying we do, but there isn't one. What the Shepherd Group did was just take two documents and define what is still existing and possible and what is not. It's not really what I would consider a plan for the downtown district. Until we get our arms around that, we're going to be struggling with trying to make these decisions. But again, I'd like to hear from council as to some of the items brought up by Mr. Smith.
Maybe this person would go to first. Go ahead.
Sure. David Meggett, City Attorney, had the pleasure of meeting all of you last month, as you may recall. From reviewing the Land Development Code, and I'm going into procedural due process here, under the provisions for a matter like this, it goes to you all first. You make a recommendation for approval or denial, and then it goes to the Planning Commission and then on to the City Council. So the way my review of it procedurally is, the procedure is being followed. When the Planning Commission meets, they will have the benefit of knowing how this board, voted on it. If the board does decide to not take action today, that could slow down the process. But if this board does take action today, I think procedurally we are proceeding in accordance with our Land Development Code.
Get to Megan first.
You're referring to section 34.211, is that where we're looking? Is where we're governing this procedure?
34347.
Yeah, I'm looking at 34-347,
Okay.
subparagraph C, and then I believe 3D is where I'm looking in the Land Development Code.
Could you read that for us, please?
Did you have any other questions, Mr.
Through the chair to the attorney, could he read that to us, please, so we all understand it?
Hold on, let me give it to you.
Mine was just responding to Gary. We have a plan because we would not exist if we do not have a plan. If you would like to argue with the Florida state statute, you're welcome to. If we did not have a plan that I have to file and do a report on every single year, this would not be happening right now. There is a plan in place. It has been in place since 1987. There have been versions of it updated. It may not be very good, I'll give you that, and that's why we are working to update it, but we have a plan, and if we did not have a plan, we would not be sitting here right now.
Hey. Do you have anything more?
Well, if the council can address the issue of the report that's required from the board to the Planning Commission and the City Council, is that something that we need to do in a formal manner?
I don't see specifics in the Land Development Code that would require that. I don't believe so. With the caveat that, I've been in this position for 4 weeks, but I have not encountered that in the research I've done this far. In a general review, I have not seen that.
So you're advising us that we can go ahead and proceed without doing a formal report, that we can vote on this item this afternoon and move it forward into the Planning Commission?
Yes, I think if this board takes action today, that is sufficient. I don't know if notice is the right word, but sufficient action to put the Planning Commission on notice of what the board's determination is.
Thank you, Mr. Chair. The CRA does not prepare the report. Raise your hand if you want to be the one to do that. That's what staff is for. That's what Christian is for, representing the zoning side of the house, Taylor on the CRA side of the house. And we bring our professional analysis and recommendation to you for consideration. No different than any other way we've done these applications with the CRA or Planning Commission. anything that goes forward to council for a final decision. So you are either accepting by recommending approval or rejecting by recommending denial our professional staff report. Because we can't have the CRA getting together, not in a public setting, we'd be in violation of sunshine laws, and have you guys draft the report. You guys are volunteers, that's not your part in this whole process. So yes, we are following the procedures. We did have all the public notice that we were required to do per code and statute, and the report, again, always comes from staff, and that's the way the process has always gone, and always, as long as the code says how it says, we'll go.
Thank you. Gary?
No, thank you. I was just trying to understand where we stand and what the criteria is, because I'm hearing different things and want to make sure that the direction that we're heading is consistent with, our process.
Mr. McGraw, I'd like to respond to the additional testimony presented by the city attorney.
I appreciate that, but you already had your time to speak.
Sorry, I had bad hearing, I really apologize.
This is the first time I've ever had somebody speak at one of the meetings that I'm leading, and I've never seen anyone come back up, so I don't know if that's...
As an affected party, I have certain rights. It includes cross-examining of witnesses,
Okay.
presenting evidence, and giving enough time to read
I appreciate it.
evidence.
Yeah,
You had your
hold on,
time.
the attorney's gonna
Okay.
speak to that. Thank you,
Are
David.
you denying me
All right,
the
I'm gonna-
opportunity, Mr. McGraw?
But
Are you denying me the opportunity, Mr. McGraw?
The Land Development Code, the City of Jacksonville Beach's Land Development Code does not have provisions on aggrieved or adversely affected parties at this stage in the proceedings. There are some references in the Land Development Code to perhaps appellate rights in the future. But in certain other cities and counties, there are provisions I've seen where someone may achieve such as a status and then have the right to cross-examine, but that is not present under the code that you all operate under, and that is, based on my experience in training, your code is in compliance with state law. That's how it's been set up, and that's how you should follow. So at this point, public comment is done, so there should be no further public comment unless the board decides to reopen it, but there's no right to speak further at this point, absent further action by the board.
I'm just trying to follow the process that I witnessed as a board member, and I've never seen it happen, so I'm gonna...
Well, he just told you, you have the ability to let me speak again, to respond to their specific
I guess I'm saying
testimony
no.
that they gave.
Guess I'm saying no for now.
Okay, thank you.
Run this meeting here.
You're denying my right to
Okay,
cross-examine
can we
the
complete
witnesses.
this
Thank you
meeting?
very much.
So what's next?
A board member would essentially either make a recommendation for approval or denial, and then whatever recommendation is made, or whatever motion is made, then we would take a vote, either way, until we basically reach it.
Any other questions from the board? If not, Francis?
I'm just going to, ask if, when we do make our vote, does it have to be an absolute yes, no, or I defer, or can you reference as to why, regardless of feelings?
So what would need to happen is either we make a recommendation for approval, make a recommendation for a denial, or in theory, someone can make a motion to table this and not vote at all today. And then at that point, whatever the motion is, we would vote. And if Mr. Miggott would like to speak to this, there is no, unless you have a personal conflict of interest with this property, there is no right to abstain from voting on this.
So, sorry, guys.
Oh, well, what I was coming up to say, Ms. Moms, basically it's mentioned it as I was walking up, but the recommended motion from staff is one of three actions that I think any of the three you all could take based on the evidence you've heard and read, and that is recommendation of approval, a recommendation of denial, or a recommendation of approval with conditions, and in such case, I would recommend stating the conditions if you feel that those conditions would be necessary to comply with the Land Development Code.
So my actual question is, if whoever makes the motion, I disagree with it, but also kind of agree with it, can I give my answer with an I agree or disagree based off these parameters, or does it have to be yes, no, or maybe?
You could, discussion now would be the best part, the chair.
So then I'll just do my last discussion point, then I'll just give an actual answer back. All right, so based off that, sorry guys, and everything else that I have research and experience, I'm not an attorney of any form. I just encourage you guys all to remember that we did pay for professional services. Those shops along Sixth Avenue North as part of new development. They're smack between the two, their street is not actually mentioned. So based off that and how I have been reading all these different things, as much as I absolutely love the idea, I think it's a wonderful addition and does our purview of bringing new business and excitement to the area, I feel like I'm bound by those two things. That's just me.
So, the plan, and Mr. Gilmore's famous for always saying this, if it's not in the plan, you don't do it. If it's in the plan, it's an allowable thing. It does not mean you have to follow it to the T. So I think that has to be up to every board member to make that determination for if you feel that that is something that does not fit with the goals of downtown, then I, encourage you to vote according to that, and if, you feel opposite of that. But what's in the plan, just because it's there, does not mean it has to be done. It's in there, so we can do it, yes, as a suggestion.
Gary?
In reference to the plan, I think we've got some missed opportunities. I think there is much more that could be done to really improve, particularly First Street. I know that you're not planning on doing anything more to Mango's other than adding a patio to it, maybe a bathroom. But there is an opportunity to do something that would enhance the edges along First Street, which is really the main corridor for our downtown and what's trying to be accomplished in the way of retail and enlivening that whole corridor up and down First Street, including the avenues that have been mentioned. I think there's an opportunity to do artwork on the corners and do something in the way of landscaping. Obviously, this is just a zoning submission, not a plan submission, and there are opportunities down the road to do some things, but I would strongly encourage that you do something more to make this part of what will be a fantastic downtown, not only for yourselves, but also for the rest of the city. The thing that we're missing also is that it doesn't relate at all to what is going to happen in the way of our urban trails concepts for First Street. That's kind of a missed opportunity right now. There are several different options that have been raised by the consultants as to what the urban plan, urban trails plan should be along First Street. And I think we need to work together to really come up with a concept that makes sense for the downtown area. Personally, I think we've got some more work to do, and I feel that sitting down and having some further conversations about where you want to go with this development. First blush, I think it's a good concept. I like the architecture. It starts to work with the rest of the architecture that's happening within the downtown. Oku and Oaxaca, same kind of style, more modern in feel, but we haven't quite gotten it to perfection. And would love to see us all work together to try to get something a little bit better than where we are right now. Thank you.
Megan?
Not to beat a dead horse, but of all the property owners, so any of the adjacent property owners or the affected property owners have gotten notice of this application and the hearing? Yes. And the reason why I ask is because I understand that the city doesn't have any access or wasn't given any data, or Mr. Smith hasn't presented any data of how this project will negatively affect any of the property values in the surrounding area. So if we don't have any of that information and everybody's been duly noticed, then I feel satisfied with that. I think changing the traffic patterns, the entrance is wonderful. So, thank you.
Christie?
Point of order, Mr. Miguel. Can I respond to the misinformation that was provided to you by,
We're in board discussion right now.
thank you.
Would there be an opportunity, you think, to make on a part of our motion to add that it would be nice if the planning commission wants to discuss any additional impact to First Street? Is that what you're thinking about? Like the whole, the idea that they could address First Street better with their development plan. Is that what you're thinking?
I believe so.
So could we that's something the planning commission can talk about amongst themselves as well, is how that, if any, like, an artwork on the corner, or something that makes it a little bit more pedestrian friendly from Mangoes to First Street.
Both the CRA and the planning commission have the ability to recommend conditions for the property. I know we've talked about this before, I can't remember what project, I think it was the Dolphin Depot project, about adding some type of architectural embellishment or live wall or art or lighting on the First Street side of that building. And that went all the way through to their approval. So you guys do have the ability to make some recommended conditions that we would then move forward. Again, council would have to accept them, but we can move them ahead on your behalf.
I'm trying to think what would be an appropriate kind of condition to put on, say, we recommend approval if, and we recommend it with the condition that some additional focus be given on to how the property interacts with First Street. But that's too vague, I think, so. Any thoughts on that?
My perspective, we don't do zoning, our mission statement is economic development. If staff is telling us it's within process and it's doing it right and they've met all the criteria, it's not, we're not rezoning anything. So, as long as everything's following the process, and Taylor and Heather, you're telling us everything is, staff is telling us it is, council's telling us it is. Francis?
I also don't want to be the horse, but our job is not to just say yes. We are responsible to our purview, right? So, like I said, I agree with you, that is our economic development is something important. Yes, there's things that have been discussed are important, but there are other things we have to take into consideration. The fact that we have one person as in the vicinity who is directly affected by this, who came to this, does speak volumes itself as only one person versus everyone surrounding the property. You look at, how the city council has challenged us to do stuff. I mean, there's a lot of things. You look at where there's residential right now versus where they are, and they're not right up against it. Like, there's a lot of things we can play with, but you're right, we are not rezoning. The problem I worry about is if they don't do the west part, they just do Mangoes, which we have been confirmed they could do. And if, based off my restraints or what have you, that is something to consider too, because if they do break it up and they don't do the west side of it, then we're not doing our purview and we're not following the parameters of this. So if there's any amendment to it, I would say you can't do Mangoes till you do the west side. You won't recount all those things because the attorney did this to confirm, not attorney, but like they just confirmed they could technically just say we did our porch, peace be with you, and then we have this whole left-hand side where they don't have to follow the requirements or work with their agency to do what our requirements are because it's all bundled together. I mean, did you not start the whole meeting with that? The whole meeting was they could, by bundling together.
That's correct, they could choose to do
They
that.
bypass certain things that we wanted to done.
I will say that with the gallery project, they proposed a series of phased improvements, and we basically said you have to do them in order. And if you can't go straight to building a new building with a restaurant without doing the infill development and the parking lot and those sort of things. So you could certainly recommend that they have to run concurrently or, within 6 months of each other or something along those lines. Again, it would have to be through council for approval, but I don't think it's a bad
So
recommendation.
that's really and truly, no matter how many things you point at and how many things, we really truly have one direct affected resident near the property that's come to speak. We have all these things and plans that we can follow and have our vision and the ideas, but truth of the matter is, if we're making a recommendation, either we're recommending it for all in or making amendments. And my only big issue is if they follow the trend of every other developer that's come to Jacksonville Beach in the past 14 years, where they start something, they don't finish it, and all we have is an updated Mangoes balcony, or porch. And that would be devastating because then everything to the west of that stays like it is. And the whole purpose of Improve It is to make sure that that gets growth and economic for the area.
Heather?
Thank you, Mr. Chair. And I know that we didn't get into like the details, some of the details of their proposed development project, but one of the things that makes it work for the applicant and the property owners is that they get the benefit of a different parking standard for a mixed-use development. So while Mangoes standalone has a very high parking requirement, when you add in the mixed-use component of this property, it changes things. I don't think Mango's could do what they want to do on their own and meet the parking requirement without the other half of the project. I think they would have a really hard time, or it would just not be possible. Because not only are they expanding, they already don't meet the parking requirement until they become mixed use. So I think based on that alone, it's, I'm speculating that they wouldn't be able to do it because we have sat down with them and looked at their parking on many occasions. They don't have enough now, they wouldn't have enough if they expanded. Standalone, they are meeting the parking requirement, the ingress, the egress, as one whole project.
That's a very important fact that I personally can use in our. Just putting that out there.
Any other questions or comments? All right, well, I will entertain a motion. Just,
I'm scared to make the motion. All right, I'd like to make a motion to recommend approval to rezone 602 First Street North to RD with the condition that they consider additional ways to add to the pedestrian quality of First Street. Very vague, but.
I'll second.
all right. So, Madam Clerk, call a vote.
Ms. Christie Alpin,
Yes.